Good morning, friends. Today we are going to have a 19th lecture on law and economics. This is actually a lecture on legal procedure and rules. So far, what we have done is actually different kinds of law, which is dealing with a different kind of problem, such as the property law and property right, which is actually enables people's right on different aspect and that makes them to claim their right and help them to transact. And then we have also seen that what is the problem with that kind of law or rights being breached or violated. So what was actually the remedy, etc., will be discussed in the property right case. Similarly, the same is applied in the case of a contract, whereas contract and the possibility of breach and the different remedies being discussed. Then we also discussed the tort cases and the criminal cases, where the procedures, the process and the theory of efficient breach and efficient remedy were discussed thoroughly. So now, once you have all this thing in place, then the question is that who is going to actually, who and how is going to be, materialize this kind of a violation. So normally we used to say that the legal system is going to. What is the legal system? Roughly, the legal system or judicial system means that it is not only those laws but the implementation of those laws, or like an enforcement mechanism. Now, what judiciary normally do is actually they try to evaluate this the strength and weaknesses of the claims which makes by different plaintiff and defendant, or the person who are injured and the injurer. So and then they make a kind of an observation, and this is basically called the legal procedure. Now, once they will pass a judgment, then that has to be implemented, which has to go to executive to execute this thing. But our point is not to dwell towards that limit. Now, what we are going to discuss today is actually the process, which is the most important part of the legal system or judicial system. Because once you have this procedure is intact, then only you can say that whatever laws or whatever rights which we have discussed earlier is going to be materialized smoothly. So therefore, the procedural rules are in different countries, different procedural rules are existing. For example, in the United States, court system developed around the common law concept of due process, which requires adequate notice and a fair and impartial hearing. For example, all federal trials are governed by the rules of civil procedure and rules of evidence. The same is actually the case because India is also a common law country, largely a common law country, because we have inherited, just like the the United States legal system, the Indian legal system also partly inherited from the British system of common law. So we also has most of the laws based on Indian Penal Code, CRP, Criminal Procedure Code. Then we have Indian Civil Procedure CPC. Then we have also the CPC, and with backed by Police Code and Evidence Act. So these are actually the fundamental laws. Most of these laws in India had been evolved during the time of British, and later we had modified or kind of amended, and we also shredded some of the provisions because of many reasons, which has to go along with the constitutional structure of the country. So with keeping all this in mind, we also have a similar mechanism, but then once all this is intact, then we will talk about an accident or a breach. Now, a breach takes place or an accident occurs or a violation of property occurs, then that point is actually the starting point of a litigation. Now, you can have if you have, as we started saying, that a bargaining system is costless and possible, then private agreements will basically take place and they will settle the problem then and there itself. But that is not always the case. So most often that kind of an incident leave or bring the same as a lawsuit in front of the court. So that is the point which our legal procedure starts. Right? If there is an accident happens, then the moment of that accident invites a kind of inquiry, a police inquiry FIR in the form of FIR, or then you file a complaint, then so all this kind of things will proceed. So in the Cooter and Ulen text, it is in the very beginning of the chapter of legal procedure. This is actually being given as the longevity of a case. All right. So, or we can say that the legal proceedings. So first you have to have an injury or a violation in the case of property, injury in the case of a tort, or contract breaches in the case of a contract. So that has to be showed as the first point, as I said. Then in that point, from that point itself, we can say that either they can settle the thing or they sue the person. All right. If they settle, that means there is a possibility of a bargaining between the two parties, that is the stranger and the stranger, between the strangers, or the contractees, or between the property owner and the violator of property. If that is the case, then things are settled and then there is no lawsuit at all. So injury and settlement will take. We will discuss about settlement later, because in the next set of lecture we are going to talk exclusively on settlement. So we are not going to talk about settlement here. So injury, then settlement, things are over. All right. Otherwise, what we normally do is actually the injury leads a suit. Okay, lawsuit. So lawsuit comes in front of the authority. That can be even in the, as I said, you write a complaint to the police station, and who is actually the party, and later you go to the lawyer and then you talk. So in that point also, without going to a lawyer, what you do is actually you file a complaint. For example, in the accident case in India and all, you do the same. So you just file your complaint, and then the police or the sheriff in United States, they will hear that who has done wrong. So then he or she will be actually opening a possibility of negotiating between the two party, and the police act as a mediator in that. So that kind of thing will actually take place. If again, if there is a possibility, or if the parties are ready to negotiate, and then the case then and there itself settled, and then you withdraw the case and things will go fine. So then there is again no lawsuit. Again, from that point, then what you do is actually, if you are not satisfied with the terms and conditions of your opponent or the other party, what you do is you file a formal complaint with the lawyer. So that is in the case of accident. It's a nice way of actually telling you a story. So if you file a complaint, then that is now goes to court again. In that, there is a lot of cross-reference, and then based on the FIR which is written by the police, or the legal points which is the lawyer arguing the court, which again makes a lot of information revealed. Okay, so you have again a possibility of settle or exchange information. Or is purely a settling or exchange information in order to try the case. All right. So after that, you will enter into a bargain between the courts, and court will hear all this. So police said, then you will use the judge will hear, that is the magistrate, the lower level of subdivision magistrate or whoever. If it is a criminal case, then it is actually the lower level of judge will hear, and otherwise in the civil case also this lower level of judge will hear. After that, if you are not happy, again if you are the terms and reference are not happy, again you have a possibility of bringing the suit, and after hearing they'll pass a judgment. All right. So that judgment, if you are not happy with the judgment, what you do is actually again you sue. So or you proceed with the trial. Now again that opens up a lot of room between the parties to negotiate, because this trial is actually a longer one. Normally in India, the trials are very lengthy. It will take years. Okay, even a small accident, it will at least take some 2-3 years to get settled. So meantime things are not going to be the same as what you think. So all this point you have a possibility of either settle the case or go for the trial. So once the trial is done, then the trial will give pass a judgment, and that judgment, based on that judgment, it will say you whether your case is actually a won or a lost. So if it is won, you are happy, and if you are happy, then the case is settled. But if the other party is not happy, then again they can actually appeal the same. So the appellate court are there. So that is higher judicial courts. So in the higher judicial courts, they go, and again the same process. The trial takes place, and either you lose or win. Again in India, again you can actually go for the third appeal or whatever. There is different longevity, and if you go for all this trial, and then from the beginning of the case and at the end of the case, it will take at least 5-6 years or on an average. Okay, in that context. So this is the kind of lengthiness of the judicial process in India. Some cases it will be very fast also, but that fastness is not that fast. At least it will take 2 years or 3. But there are certain cases which we had already studied, decades long cases of civil suits, and even we have century long cases in Indian courts. So my own study says something like that sort of, especially the study on which is having a passive reference on the same, that is the pendency, filing, disposal and pendency of Indian courts, a case of Andhra Pradesh, which was exactly referring to the time and the efficiency of passing a judgment. So this is actually about the longevity of the cases which we talked about. Now, as I said, as the legal procedure, you have Indian Penal Code, you have Indian the Civil Procedure CPC, which I missed writing. So you have a CPC, you have IPC, you have CRPC. Okay, these are called the fundamental rights, which basically deal with this case. So civil lawsuits are based on the Civil Procedure Code, and the Criminal Procedure Code and the Indian Penal Code is actually the basis of the criminal cases and its trial. Now all this is basically based on the Evidence Act and the Police Act. So the Indian Penal Code, as I said, was inherited from the British Empire or the British India. It is actually the structure was built during the British period. That is 1860 was the IPC formulated. It deals with substantive criminal law of India. It defines offences and prescribes punishment. Criminal Procedure Code, again, it is actually a new one in 1973, where it deals with the procedure of investigation and criminal proceedings. So it provides mechanism of punishment of offense against the substantive criminal law. As I said again, we have the civil procedure code, which is also old, and now we had a 2002 we have a reform of civil procedure code. So based on that, we have a different kind of possible lawsuit, and that appears in the court. So backing all this thing is basically done by Indian Evidence Act of 1872. So it deals with a different category of evidence, procedure of collection of evidence, preservation and use of different evidence. It is common to both civil and criminal procedure. So criminal law that is deals with offense which are against the public interest, as I said earlier, and we had a lengthy lecture on it. Here the state is one party represented by the public prosecutor, and accused is other party. Then you have a civil law which deals with the dispute between two individual or parties. One party in civil case is known as plaintiff, the other party or accused in both civil and criminal cases known as defendant. So if there is a crime takes place, because we are largely interested to just like to give more priority to the criminal, because that is the last lecture which we talked less about this thing, so I have to give more importance to this. So it is an inquiry. Inquest is always made, that is, if inquest is nothing but it's an inquiry on investigation into cause of death. So two types of inquests are there: police inquest, magisterial inquest. So police inquest is based on the CRPC Criminal Procedure Code of 1974 by police officer, usually sub-inspector, and if it is a popular case and all, like a public pressured, higher officers will basically look into. But normally it is sub-inspector supposed to make this inquest. And CRPC 175 investigation officer is presented to local person known as Pancha, makes an investigation at the place where body is found. So this is what is the procedure. This is what is the first investigation of the inquest. So magistrate inquest is based on the CRPC 176. So conducted by magistrate, DMS, DM or Tahsildar, or sometimes even executive magistrate, by magisterial powered by the state. Okay, so conditions for magistrate, such as the district collector and all, comes under this magistrate having this magisterial power. So conditions for magistrate inquest is actually death in police custody, death due to police firing, death in prison, a reformatory or postal school, death in psychiatric hospital, dowry death within 7 years of marriage, exhumation, any person dies or disappear, or rape in custody of police or any other custody authorized by court. So such cases only been made a magisterial inquest. So court of law again are different types. As I said, in India you have a civil court and criminal courts. Criminal courts are of 4 types: Supreme Court, High Court, Sessions Court, Magistrate Court. Whereas a civil court is a sub-court, and you have municipal court, sub-court, and then you have district court. All right. So then you have High Court and the Supreme Court. So all the procedure, the Higher Court remain as it says. So juvenile courts and regarding the civil courts, there will be the financial and the amount and the gravity of the cases is actually makes the case goes from a lower to an upper ladder. So then you also have a juvenile court based on the fact that the children differ from adult in mentality. The trial of committed by juvenile age below 18. Now you have in the recent Supreme Court verdict on Nirbhaya case, you have now a relaxation of the age in that sense. So juvenile court is usually presided by women magistrates. Now offenses means act or omission made punishable by law, as we have called bailable and non-bailable, cognizable, non-cognizable, reversible offenses. It is an offense in which the police officer can arrest a person without the warrant from magistrate. The person is sent to doctor for medical examination. In non-cognizable offenses, the injury person may go direct to the doctor or may file an affidavit in the court of magistrate who will send him to the doctor for examination of the report. So Then powers of judges also very important, because the chief judicial magistrate has the power to imprisonment up to 7 years and unlimited fine, whereas first class judicial magistrate is 3 year and 10,000 rupees, and second class judicial magistrate is 1 year and 5. So that itself shows that actually the powers of the judge and the gravity of the case comes in front of them. So based on that, they have this kind of same in sub court, or that is in civil court also, the fine, the amount of fine is actually going to be determined by the powers of the judge. So we have, as I said, civil procedure code, that is code of civil procedure 1908 is what is we have. And in that you have a civil court, that is high court, district court, sub judicial court, municipal court. Now, high court and district court can actually deal the case of any amount. Okay, and sub judges court also have an. But municipal court is having a limit of 1 lakh rupees. So if it is more than 1 lakh rupees, then the case goes to sub judge or the higher. So process issued by court is actually summons, warrant, notice. So summons means issues to appear before the court in person or through advocate and answer to the question, claim, or procedure document. Then warrant and order to arrest, procedure, search, etc. So then you have notice to intimate the institution of a petition, proceedings, or its date of hearing, etc. So injunction says that, or injunction or stay order is prohibitory injunction. Stay order is issued restraining a person or authority from doing any act of things, etc. Mandatory injunction is issued ordering a person or authority to do any act or things. Status quo is also issued when necessary. So these are actually these things based on the civil suits. And writs are the newer kind and issued by Supreme Court under Act 32 and High Court under Act 226 of the Constitution of India. The writs are habeas corpus, mandamus, prohibition, quo warrant, and certiorari. Then the writs are issued by the apex court and the high courts for the enforcement of fundamental rights guaranteed under the Constitution and any other purpose also. Again, any person or authority governed. And second appeal is actually, as I said in the earlier case, in the trial goes, you have a first appeal and then you have also a second appeal chance in India. So second appeal to the High Court in Q was a substantial question of law exists, and after the in the decree passed by the lower appellate court or from the ex parte appellate. So second appeal is a kind of a constitutional or a kind of a substantial legal question or question of law exists. So then you can go for it. And again, this is also gives a based on judgment, or means the statement given by the judge on the ground of a decree. So a decree means the formal expression of an adjudication which determines the rights of the parties with regard to the matter in controversy in the suit. So the purpose of court rules is actually a rule, that is scope and purpose of the rule is that they shall be construed and administered to secure the just, speedy, and inexpensive determination of every action. So this is what is actually the scope and purpose of the rules. But unfortunately, our study itself says that actually the possibility of a judicial trial is very lengthy. Not only because, and this is not because of the court per se is doing it, because of the lesser number of judges, proportionally lesser number of judges, proportionally lesser number of infrastructure and all. That in fact, or the number of cases turn up and the number of disposal and the times which they adjourn the case, or kind of the trial. In the trial also the people ask time. So because of the time, many times, if many cases, what we found is that the asking of adjournment is very high, or what you say that that itself is actually lengthens the time. So because of the party's interest, often also get reflected in the delay. As the same at this, if that has happened, then it will affect the entire docket of the court. So that means every case is having an increased probability of getting procrastinated. So this is what is actually happens. So this curtails this provision of a speedy and inexpensive determination of every action. Now this is what is called the delays, a delay of courts, and we are not very infamous. There is a lot of studies which is turned out in India about the explosion litigation. There are two type of literature turned out in India. One is litigation explosion papers, and the other one is delays actually. So, for example, the former Chief Justice of India was Sabharwal, Justice Sabharwal. He had actually brought out a piece regarding the delays in early 2000s, and I think in 2016 itself he brought out with a data set. So it is in fact a very alarming kind of data which was actually brought out, and many people had talked about the delays in Indian court, including my own study. Then we had also a couple of studies which talks about the explosion of litigation, that is increasing number of alarming rate of an increase in the explosion. Now there are many people said that this is actually an explosion taking place in the litigation, the courts, and it is very bad. And for example, Mark Gallanter's work on litigation explosion in the United States had a reflective sense in the Indian context when people like Bakshi and many people had actually worked on this aspect. So litigation explosion is one way to understand the court procedure. On the contrary, there is another set of issue which is also the delay reflective of this. So additional purpose of the court, despite of that fact, to regulate the business of the court, control conduct of litigants, establish uniform procedure, and provide parties with information and instruction about proceedings. So, these are all part of the business of this court. So, if business of the court has a lot of things to do like this, then it will also reflect on the trial of the cases also, because fewer number of judges and the infrastructure will again elongate the time of the case being tried as well as get settled, or a verdict being passed. So now so far we haven't talked about the procedure of the lawsuits, because we talked about only theoretically what does this. So purpose of civil procedure is the just and efficient resolution of a dispute. This is what is the fundamental principle of any suit, and based on the guiding premise of the due process law, notice must be given to an individual being sued. There must be an opportunity to respond. Now, complaint, a civil case begins when a plaintiff files a complaint, a notification to the defendant that he or she is being sued for what reason. State why court has a jurisdiction, provides statement of the fact, states a cause of action, legal theory about why plaintiff is entitled to recover, specifically a remedy. Now, the formal notification of a defendant referred to the service, and often they involve summons, a notice informing the person that a lawsuit has been filed and that she should appear in court at a certain time, often delivered by the local sheriff or authorized private process server. So can sometimes be difficult to deliver. Defendant may go into hiding. Now, answer is the defendant's written account responding to the complaint, and federal rules allows 20 days for answer. In India, you have 30 days to answer. Failure to respond may result in a motion for default judgment, which is a victory for the plaintiff. Now, common response including denial, affirmative defense, or counterclaim, etc. is there. Here also you have the same. The complaint and the answer together makes up the pleadings, the formal written statement about a case. The pleadings can be amended during the course of the lawsuit as new information become available. So you keep plead the judge based on the information which you evolve through the case or trial. So discovery, that is, discovery involves a formal and informal exchange of information between the two sides in a lawsuit based on the philosophy that before trial, every party is entitled to disclosure of all relevant information regardless of the source. So counter to the idea that information should be privileged. So designed to equip both sides fairly. So this is, I think it's ideally there, but most of the time it is not necessarily there. So discovery privileged information, that is, reflects the idea that some information should be kept confidential, which is privileged information. Courts recognize the lawyer's client relationship, husband, wife, doctor, patient, clergy, penitent, and journalist source. All this called the privileged information. All except lawyer, client are considered to be qualified, not absolute. Now, tool of discovery is deposition, the sworn testimony of a witness taken out of court. If a person refuses to appear for their deposition, a subpoena might be issued. Provides information to both parties. So production of document, to the voluntary sharing of all document relating to the case. If a party refuses subpoena, ducus tecum can be issued, which is a court order requiring the production of document in the case. So interrogatory case also there. So series of written questions from one side in lawsuit to another. Lawyers use interrogatory is to get answer to factual questions or to get an explanation of the other side's legal contention. So the tool of discovery are intended to allow both parties in case to share information and guarantee that a decision will be made based on the merit of the case. Now, a motion is a request that a judge make a ruling. There are a variety of motions grant a victory to one party without a trial. One type is a summary judgment, which says a party should win even if the allegations by the other party are true. Judges and lawyers or parties use a pre-trial conference to discuss matters associated with the pleading issues of fact and law, etc. may also be used to get parties to try and reach an early settlement. Now, the court's official decision in lawsuit is called judgment and court order or decree. So, if a defendant does not voluntarily comply with judgment, the plaintiff must take further step, permission to seize property, garnish wages, etc. So, negotiation and settlement disposition, approximately 95% of all civil cases filed in federal districts are settled before trial. This is in the United States case. Voluntary settlements are the norms for cases, but in Kerala, India, you have a very different picture, and in fact we don't have actually a very clear cut data set for this thing. So negotiation is where the parties in a civil suits are able to reach in settlement. A settlement benefit to the litigants and save the system money. So intensity of negotiation, evidence suggests that there are relatively few offers and counter offers. The intensity varies by type of civil cases, more in tort, less in divorce. The entire system expects parties to settle. One study showed that lawyers spend approximately 10% of case time on settlement issues. So best result negotiations, that is, lawyers focus on obtaining the best possible settlement for their clients. Appropriate result negotiations, and lawyers focus on getting an appropriate result given the alleged fact. So less adversarial, that is used where evidence and liabilities are agreed upon. So these are the kind of things, and you are also called a ritualistic negotiation, where lawyers and parties go through the motion of negotiation. But the disposition of the case appears obvious, but the system expects negotiating behavior. Settlement is obviously in a civil case or plea bargaining negotiation in a criminal case. Normal penalties. What is the cost benefit analysis lawsuit? So let's talk about that. The following factors should be considered in deciding whether to bring or settle a lawsuit: the probability of winning or losing, the amount of money to be won or lost, lawyers' fees and other cost of litigation, loss of time by managers and other persons, the unpredictability of the legal system and the possibility of error. Other factors peculiar to parties and lawsuit are the long-term effects on the relationship and reputation of the party, the amount of prejudgment interest provided by the law, the aggravation and psychological costs associated with the lawsuit. The pursuant to the Seventh Amendment to the U.S. Constitution, a party to an action at law is guaranteed the right to jury trial and in cases in federal court. So in the United States, this is the case, and most state in India also you have this trial is, and no, we don't have in fact a jury. So we have all judge in front of the judge only. We don't have actually jury to deal with the cases. If their party requires so jury trial is different. So phases of trial in the jury trial or jury selection, opening statement, plaintiff's case, defendant case, rebuttal and rejoinder, closing argument, jury instruction, jury deliberation, interview judge. Whereas this is not the case within India. You don't have, I mean, in normal case, you don't have it. So the appeal. In civil case, either party can appeal the trial court decision. Appeal can be filed once final judgment is entered. This is the same in India also. So in a criminal case, only the defendant can appeal. So the appeal is made to the appropriate appellate court. Notice of appeal must be filed within prescribed time after judgment is entered. And method of resolving dispute other than litigation developed in response to the expense and difficulty of bargaining a lawsuit. So in India, we have also an additional mechanism being invented because of the hue and cry, which has emerged in the in the late 1990s. So the litigation explosion literature, which I was referring, litigation explosion. Litigation explosion literature brought out a lot of new mechanism to deal with such delayed cases as well as pending cases in the court. And for example, they were made this as bypassing the formal judicial system, which is called the ADR or alternative dispute resolution mechanism, such as arbitrage, mediation, conciliation, mini trial, fact finding, judicial reference, etc. So there are fast track courts, for example, is the result of that in the 1990s. Okay, so these are all the new gen kind of dispute resolution mechanism in India, and we have arbitration, which is parties choose neutral third party to hear evidence and testimony and decide the case. Arbitrator make a decision and enter an award. Arbitration may be binding or non-binding. Now, key ADR legislations are the Arbitration Conciliation Act of 1996. Adopted by Government of India promotes the arbitration of dispute at various levels. Now, mediation is mediation, conciliation, and mini trials are the other forms. Like parties chose a neutral third party to assist them. Parties reach settlement. Mediator does not make judgment or issue reward. That is the only difference. Whereas arbitration, in the arbitration, they do. So conciliation, party uses an interested third party to act as a mediator. That's it. Mini trial, short session in which lawyers for each side present their cases to representative of the party who have the authority to settle the dispute. So then you have fact process in which the parties hire a neutral party to investigate the dispute and report finding back to both sides. So this is in fact the friend of court like amicus curiae and other thing kind of thing like a fact finding mechanism. So judicial reference, that is a court appointed referee who conduct a private trial and renders a judgment. Parties reserve the right to appeal in that side. So with this the judicial process is this thing. Now the benefit and the efficiency of this is actually depends on different studies. There are very few studies in Indian context, economic studies basically on Indian context on this thing, but there are many studies already taking place across the world in different universities regarding this matter, which one is efficient or fair, etc. So we have to now understand there is a lot of possibility to do research and studies in this aspect of procedure of court and if effectiveness of different court mechanism or judicial mechanism to make our the laws effective or the channel of basically make an efficient transaction or economic gain to the parties. With this note, I conclude this session. Thank you for listening, and thank you once again all to all of you.